Welcome back. Well, today we've got Mr. Wahab Shitu, who is a counsel to the AFCC, also a lecturer in the Faculty of Law, University of Lagos, and sitting right beside him is Monday Obani, who is the former second vice president of the MBA legal practitioner. Gentlemen, thank you for coming on this morning.
Thank you, Chamberlain.
Well, before we even delve into that, regarding matters raised at that MBA week, this current matter, which has been all over the place, the P&ID case against Nigeria, there's been several comments. In fact, there's still different perspectives making the rounds. Yesterday, the officials of government met to review proceedings and see perhaps how, what they need to do moving forward. But if I could start with you, Mr. Shitu, what do you think of all of this that's making the rounds at the moment?
Honestly, my view is that this is a monumental embarrassment, given the quality of human resource capacity we have in this country, and the quality of lawyers who are well qualified, who are reputed, and given the reputation of our country, is a monumental embarrassment. The award of $9 billion against the country at this point in time is so huge. You have a heavy toll on our resources. But I think that's looking at it from the surface. I think we need to probe deeper. Who are those who put us into this mess? Who signed the contract? You see, yes, there's a government in place right now. But this whole transaction did not start with this government. It started as far back as 2010. Who were those who entered, or whose authorization was this contract entered into? Particularly when all of us knew that the sitting president at the time was away in Saudi Arabia recuperating. And was this a contract brought before the Federal Executive Council for deliberation and approval? The sitting attorney general said the contract was not even brought to his attention for vetting. That shows that we were put into this mess by elements who are not patriotic. And that aspect has to be investigated. That's one aspect. The other aspect is our reputation as a sovereign state and our obligations under international law and by virtue of contracts. When a contract is entered under international law, it is binding. A pacta sunt servanda. I mean, all agreements will be implemented. That is, those who have, the knowledge deep knowledge of international law will tell you this for free. But again, my own perspective is that I won't find ourselves in this kind of embarrassment. The way out is a negotiated settlement.
Well, Mr. Obani, on the one hand is the way it's all. On the other hand is the position of the then Attorney General that the process was all warped. So if the process was warped, is it still binding?
Well, that has to be presented to the judicial authority. If you are saying the process wasn't followed strictly, was that presented before the arbitration panel, before the arbitral awards was made? These things are very key, and if you have not done that, could it be allowed even on appeal? Because the importance of that process which you have mentioned must be brought to the attention of the court. This is that in Nigeria, before such a contract of magnitude, becomes binding, there are process and procedure that the Federal Executive Council has to look into it and approve it. And that was missing at the time this so-called contract was executed. And in the absence of that, these are the legal consequences. So if you don't bring that information to the you are now seeing, doing what we are doing now, because I saw some people protesting yesterday at the embassy and all that. It goes to no issue. The courts don't operate that way, not on sentiment, yes.
One other thing that, I've had to also mull over on this issue is if the whole process was fraught with, from the very, very beginning, why did we have representatives at the various stages between 2010 and
yes.
this year?
You didn't even know about this. It's only when this arbitral award of $9 billion was pronounced that most of us got to know that there was even a case like that of magnitude in court. So you now begin to wonder what is even the of representation. The annual conference that just ended, facing the future as a team. And part of the thing that came up was this issue of ensuring that lawyers who are handling cases of clients are well skilled in the act of service delivery, because the future is there and we must get it right. And so if the necessary clauses were not inserted at the time this particular contract was executed, and we are now discussing it after ruling has been given by the arbitration panel, then to me it goes to no issue. That's why we must begin to put our houses in order and make sure that the right thing is done. If you want to do contract, let the people that are skilled and knowledgeable be the ones to draft such contracts. And then the processes must be followed. If you don't follow process and you now put Nigeria into such a magnitude of, of debt or problem, then there are consequences, which what he's saying now. There must be a proper investigation and punishment for those who put us in this monumental mess.
So Mr. Shitu now, he has talked about, the way forward. This is where we find ourselves at this moment, and we need to find a way forward. Now, if you look at, P&ID, for example, they've put out so much information online from 2006, 2008, when there was a meeting, to 2010, sort of detailing what exactly transpired. And, this is open to everyone. So for Nigeria, how do we handle this moving forward?
Well, the first option is a negotiated settlement. We reach out to those. The Irish engineering company has been doing business with Nigeria in the last 20 years. Don't find out. P&ID have been here in the last 20 years. It means they have had strategic business interest in Nigeria for over a long period of time. We can engage them. That's one way. Secondly, we need to constitute people who are actually knowledgeable in these matters. You might be a lawyer, but you are not knowledgeable in all fields. For instance, I cannot claim expertise on arbitration matters. There are people who are versed in such areas.
Yeah, so why do lawyers offer themselves for that?
You understand me? We should reach out to these people. People who are knowledgeable not only about arbitration matters, but also those who are knowledgeable about the workings of international.
Yeah, but let me follow.
And here,
Mr. Shitu, just a minute. If I could follow up on that, should lawyers offer themselves for arbitration if they know they don't have the skill in that?
They should not. They should not, because that is professional misconduct. If you don't have expertise in a particular area, seek help. For instance, we have an expert on treaty law in Nigeria, for instance, who is even recognized by the African Union, Professor Akinoyibodi. Such a person should be consulted. But we need to also consult those who are versed on arbitration matters. I'm aware by Ojo is one.
Yeah. So many of them.
So many of them now, right now. The firm of Alikoyibodi and the firm of Onaniwa Anyanko. These are lawyers who are versed on some of these matters. But have you consulted them?
Okay.
So the way is a negotiated settlement. That to be driven by those who can deliver expertise in this area. We need to enlist the services of experts, those who have expertise in these areas. And I've mentioned Professor Akinoyibodi. I've also mentioned those who are versed on arbitration matters to assist us. Nigeria is not lacking in terms of human resource capacity, but we are not making effective use of those who have.
But at the moment, the narrative from the government is that, yes, there will probe what's going on. And I heard some quarters that they are going to apply for a stay. So does that suggest that if they apply for a stay, if they do get a stay, are they going to appeal the case, but you're opting for negotiated settlement?
Yes. Again, this judgment, it is, when a judgment is handed down, it is binding. So if you agree against the judgment, the option open to you is to appeal against the judgment. That can also be pursued side by side with.
Would it be wise to appeal?
Of course. If you don't appeal. So
where does negotiated settlement come in? That's
in between some of these options. I mean, they go together. You understand what I'm saying? If, for instance, what I'm saying is that if I'm in court with you, and we're in court without prejudice to the proceedings going on in court, if we reach agreement. Out of court, and which is an option that should be pursued. I'm saying that, again, government must also go to the root of this matter by finding out those who put us into this mess. And I'm aware EFCC under Magu is carrying out detailed investigation on this. And they have unraveled some facts which will soon be brought out. to throw more light on some of these issues. I got that information.
But does that, gentlemen, does it invalidate
No,
the judgment and what we need to do moving forward?
What invalidates what? Unless there's a contrary, unless there is a contrary position by an appellate court, what is has been handed down is binding.
Yes.
But what he's saying is that there are options you can pursue even when the matter is still ongoing at the appellate, place. You can still negotiate outside, and of course, when you reach an agreement, you now come back to the same court and say, look, we have agreed, and these are the terms of settlement. The court will actually willingly be, ready to listen to both parties who have actually reached an agreement. So it's important. But this issue of trying to now, paint this in a bad light by protesting and all that, it doesn't affect the court. The court is not bound by all those processes you are carrying out in Abuja. Go to and deal with the matter squarely and have this matter resolved. Negotiated settlement will be the best way out.
I'm speaking about the future.
Without doing this.
Which one?
Without,
doing what he said?
Oh, yes, confronting the matter frontally. Nigeria is obviously endangered in terms of our foreign reserves,
and capital, and assets. And assets.
And we need to do something quickly.
Lawyers are, in the manner of speaking, they are the center of all of this, of course, because, lawyers, they would have advised clients, they were at the arbitration, they play a huge role. But in that conference that you held, talking about the future, there were some very interesting perspectives. Cases of human rights came up, cases of even the IBA president's submission concerning what was going on here about the cases with Nigerians. But conferences you've held several conferences. How is this one any different from the previous ones, Mr. Bani?
Well, this one, of course, you listened to the communique. You must have read it. Part of the recommendation is that a monitoring committee will be set up in MBA to ensure that most of the conclusions, most of the suggestions, reached in that annual conference is clearly implemented. Because most times it's like it's a talk show. We come to MBA conferences, we say certain thing that is basic, and ready for implementation, but nobody monitors whether these things are implemented. Many areas we are dealt with, as rightly pointed out, the issue of human rights, the issue of infrastructural deficit, the funding gaps, how do we fund our basic infrastructures and get them running?
Could you jump to, because there was this clause, this part that when we raised it, lots of people were kind of surprised. The bullying and sexual harassment.
Even within the legal profession, yes, it's another issue that was discussed, and even recommendation was made that we should even amend our rules of professional conduct in order to include it, because there has been instances where principal partners harass the female workers sexually. In fact, a particular story was said of a particular principal that traveled with a lawyer abroad, and there was no arrangement for her hotel accommodation. In other words, the principal was looking for a way for the lady to sleep with him in the same hotel room. So these are issues that that crop up, and and they are hidden. Their people are not speaking out, and so these issues were brought out during the annual conference, and we're saying, look, let's try and tinker with the rules of professional conduct in order to include most of these things that will actually make any lawyer to be liable for professional misconduct, yes.
Just to be clear, that report that was, released or at least talked about by the IBA president said about 50%, of female lawyers have gone through sexual harassment, bullying. Even male lawyers are not exempt from this. And, I was looking at the communique that was released. I think it was item 13 that talked about the prevalence of bullying and sexual harassment in the legal profession. So, apparently, if you say you're trying to, upgrade, the laws and ethics of the legal profession, apparently this was not handled specifically before. So what are you looking to put into it to serve as a deterrent on one hand? And how much protection do you offer, if I can use that term, victims of this?
Law doesn't make provision for every situation at any point in time. It's only realities, the new reality, the new trend that makes people to make law. And that's why you have alteration, fourth alteration, first alteration, and all, even amendment of the Constitution of America. And so we have looked at the rules of professional conduct. It may not have been very encompassing with regards to this new trend of bullying and sexual harassment. And the suggestion is, look, let's look at our professional rules. Is there anything we can now do to improve on it, to actually act as a deterrent? And if we don't do it, then it will continue. And so that was suggested. And as I said earlier, a committee is going to be set up to look at all the recommendations that was made at the annual general conference in order to ensure implementation. And one of the implementation is that we must tinker with our rules of professional conduct in order to include this new trend that is now cropping up in the legal profession, and that is issue of bullying and sexual harassment. So it will take care of it and acts as a deterrent.
So eventually, is it possible that a legal practitioner that has been found culpable will perhaps lose license?
Of course, it's going to be a debate. That's what it means. If it is, if it's put in as now a condition that if you do this, these are the legal consequences. Just like with issue of eating a client's money, if money is put in your, this and then you squander the money, it becomes, part of the unethical rules. I mean, you can be, liable for. I mean, a lot of lawyers have been, and we've been doing it. In fact,
those appear to be the predominant case with the LPDC.
Yes, mostly, tampering with clients' money. Now, the issue of sexual harassment and bullying, it may likely be part of the rules, so that if any time a lawyer does that, then these are the legal consequences. So it is reality that creates law. You don't begin to envisage a situation that's not in control. It's only when it happens, it's okay. Gentlemen, there are deficiencies in this law. What do we do now to take care of it? And that is actually what is being suggested.
Just one more. So how soon would we see this, this?
Before, in fact, the report is that by next annual general meeting, the committee should be able, and I hope that Mr. Paul Osoro, the senior advocate of the current president, we really go, out to set up this committee before the next meeting, because that is what the communique said, that the committee will be set up to actually look at all these recommendations that have been made in this annual conference in order to ensure that it's implementation. So there will be a report presented to the annual general meeting next year to show that there has been an implementation or certain level attained in the implementation of those recommendations.
Another thing that the law probably didn't preempt before it came up was social media. And item 7 of your communique also talked about that. So what's the arrangement about that, Mr. Shitu, if you will? What's the position of the law at this moment, and what is it that needs to be done? Because part of the recommendation is that the legislature should enact robust laws that will balance the rights of freedom of speech and the prosecution of crimes engendered by social media.
Of course, you know that the social media has its positives and the negatives, and all of us are familiar with that. I think, first and foremost, we need to commend the NBA for coming up with a very magnificent team facing the future. But I also thought that maybe that team may have been modified to say facing the future with justice. Because the reality is that we cannot face the future if we lose sight of the element of justice, which is what is required. Apart from, also very crucial is the need to fight corruption frontally, even within the NBA, and then the justice delivery sector. Lawyers are quite conscious of this. And like I also mentioned, the legal profession is becoming increasingly sophisticated. So skills are required. So we are concerned as lawyers about quality delivery services, how we can enhance the quality of professionalism, how the services that are delivered to by lawyers are top notch.
I directed that especially to you because you are also a lecturer.
Yes.
And today's lawyers are very social media active, technology savvy, and all of that. So that's what I'm just. What would be your own thinking, going forward as far as social media and law is concerned?
Well, my own perspective would be the social media, in terms of the negatives I've mentioned, has to be regulated. We need to regulate it because, for instance, a lot of reputations,
How do you think that can be done effectively?
Well, it can be done effectively by identifying some of the negatives, and then directing legislation towards forestalling such negatives. And then again, that also requires expertise. There's no way you can legislate against the ills and negativities in the social media
Okay.
without expertise.
Okay.
Yes.
Mr. Obani, on one hand is the social media freedom of speech. On the other hand is that of other people's rights. How do we draw the balance?
Yeah, where your right stops is where somebody's right, starts. And so the issue of fundamental right to freedom of expression is key. It's important. It's a provision of the Constitution. But at the same time, you must not use your freedom of expression in order to damage people's reputation. And of course, most of the laws that were enacted did not envisage the advent of the social media. And the way it's going, more technological advancement in that area is being made every day. We didn't know about WhatsApp and all that thing that are coming up every day. And so issue of balancing that right of freedom of expression and also balancing the right that you don't use the social media, to damage somebody's reputation and go scot-free is something that experts will come up, to come up and enact a law that try as much as possible that regulate it properly. Remember the Evidence Act that was amended in 2011 that takes care of admissibility of internet document. Before then, yeah, of course. Before then, we were having issue as admissibility of materials from computer generated. Until people sat down and said, look, we didn't envisage the Evidence Act was of 1945. We're now in the 21st century, and there is everyday technology is there is breakthrough and all that. So we need to now look for a way to allow admissibility of computer generator, and that was why. But even at that, people are still saying that even that 2011 law was a replica of 1968 evidence law of UK. So there has been so much improvement even made before we now copy the UK 1968. So we need to be up and doing in amending our laws to actually be in tune with reality. And if you are not doing it, you run into problems.
The other issue is the issue of fake news that is prevalent with the use of social media. He has mentioned the issue of reputations, being, damaged by the social media. Again, fake news. I'm sure that a lot of concern has been expressed on this going forward. So I think we need strict regulation so that the social media, is not deployed. The social media is not deployed for abuse.
Just briefly, now, a lot of people have compared the FBI's investigation.
Unfortunately, that's right on the cue that
Right
we
on
need
the
to
side.
go.
So we need to go bail.
Yeah,
I want to say this before we
time
go.
flies.
Yeah,
But
I
if
know.
you say that, we might have to. I don't have pounds
just 1
to
second.
pay.
Just 1 second. I know your time this.
Mr.
I just want a situation
They're
where
going to cut us off, so I need to go. Mr. Monumental is the former second vice president of the MBA.
I hear you.
Mr. Wahab Shitu is a lecturer in Faculty of Law, University of Lagos, and also counsel to EFCC. Always a pleasure to have you, gentlemen.
Well, our pleasure to be here always.